Hey everyone, this is Laura from The Real Laura B, and Tea Time is here today. I'm going to do a series of shorter videos from the unsealed documents, more subject specific, than try to go over the entire thing. I do have one video out that was a quick look, a quick review, and today I'm going to do something more specific. And this one really bothered me. Did Elaine Bredehoft try to take advantage of a witness with dementia? That's what we're going to visit today. Hi, I'm Laura, also known as The Real Laura B from Twitter. I'm a researcher, truth seeker, and a new wave internet journalist. I'm not a lawyer, nor offering any legal advice. Join me on a journey to draw the curtain back to expose key news developments in the world of celebrity lawsuits and current events. Let's get started. Welcome back. Here we go. So this is going to be about Johnny's ex-lawyer, Jacob Bloom, and how they tried to depose him in the Virginia trial. But let me give you history first on Jacob Bloom. He was Johnny's ex-entertainment lawyer. He was in the same group, I mean, not business group, but that time period with Tracy Jacobs and the management group TMG. Johnny sued them, and he sued his lawyer after Adam Waldman and Ed White dug deeper and deeper into his finances and found some things that just didn't seem quite right. Johnny sued Jacob Bloom on October 17th, 2017. So it was a very busy time that year. Johnny had a lot going on, and it's more than likely why he was just happy to settle with Amber and get that in his past. He accepted it wasn't going to be fixed, and he had TMG to deal with. He fired Tracy Bloom the same time, got a new agent, Christian Carino, got new lawyers, Adam Waldman, Ed White, new business manager, and he also, through Adam, got Ben Chu, and he just had a lot on his plate. So I thought, for history, for research, let's go over what the original lawsuit was about, and have your tea ready or whatever, because this may be a little bit. We're going to go on a small deep dive. So this is the lawsuit Johnny filed against his prior entertainment lawyer. He sued for breach of fiduciary duty, legal malpractice, unjust enrichment, violation of the California business codes, and he wanted a declaratory judgment, but ended up also wanting a demand for trial. So he wanted both. So there's certain areas he wants the judge to decide, and there's certain things he wants the jury to decide, is my reading. But we do know, just so you know, they settled. But let's go on to see this. Plaintiffs John C. Depp, Scaramanda Brothers, LRD Productions, and Infinitum Nihil. Collectively, the plaintiffs, by and through their undersigned attorneys, bring this action for breach of fiduciary duty, legal, this is a little bit small. Let's see if I can get this a little bit bigger. Legal malpractice, unjust enrichment violations. Well, we just read all that. Against Bloom and Hergott were the main ones that he worked with, Jacob Bloom. Jacob Bloom, yeah, was the main one. Mr. Depp is one of the most sought after and highly paid actors in the world. Like many successful artists who depend upon professionals to advise them, Mr. Depp trusted and reasonably relied on defendants as his attorney to handle his legal affairs competently and ethically. But instead of protecting Mr. Depp's interest, defendants engaged in misconduct for their own financial benefit, violated some of the most basic tenets of the attorney-client relationship, all to Mr. Depp's serious financial detriment, causing Mr. Depp substantial economic harm. Defendants engaged in self-dealing and pursued and undertook transactions in the face of undisclosed conflicts of interest for their own financial benefits over that of their clients. Defendant is knowingly, recklessly, or negligently failed to disclose to Mr. Depp the years of misconduct engaged by defendants and Mr. Depp, then attorneys and business managers, who were providing both legal and business management services, the Mandel Company, the management company. So it's known as both names, TMG. Despite a clear duty to disclose such misconduct to Mr. Depp, and defendants like TMG each collected over $30 million in contingent fees based on Mr. Depp's variable income paid out to TMG without, among other things, the statutory prescribed written contract and in clear violation of California law. That's going to haunt Bloom. And I think that was a declaratory judgment that they asked for, that they should not be allowed to do business on verbal contracts alone, as I recall. Based on their legal, ethical duties, defendants should have been Mr. Depp's closest and most trusted advisors, putting Mr. Depp's interests first and seeking to safeguard his financial and legal rights. But because of their actions, Mr. Depp now must seek redress from the very people who should have protected him. Defendants' breaches of fiduciary duties, unauthorized taking of Mr. Depp's film residual and other economic rights for themselves, conflicts of interest, self-dealing, legal malpractice, and clear violations of California law cost Mr. Depp tens of millions of dollars and continue to negatively affect Mr. Depp to this day. By this complaint, Mr. Depp seeks compensation for the serious harm defendants caused him through the improper conduct. So here we have the parties. Johnny's companies here that are listed are his production companies and his loan out companies. So we see them repeated a lot. Jurisdiction and venue, well, all the business happened in California. That's where Bloom's office is, and that's where Johnny resided, and his businesses are licensed. Mr. Depp has achieved great success in his acting career. Mr. Depp is one of the most prominent actors in Hollywood. He has appeared in over 50 motion pictures during the past 3 decades. Mr. Depp has been nominated for numerous major acting awards, including 3 Oscar nominations for Best Actor in a Leading Role, 5 nominations for Critics' Choice Movie Awards, 10 nominations for the Golden Globe Awards, and 3 nominations for the Screen Actors Guild Awards. He's also won 14 People's Choice Awards, including Actor of the Decade in 2010 and Favorite Movie Icon in 2017. He won again that January, as I recall, 2018. Films featuring Mr. Depp grossed over $3.1 billion in the box office in the United States and over $7.6 billion worldwide. These are the entities from his business operations. Despite Mr. Depp's professional success, he, like many artists, has no training in law, accounting, finance, or business management. Throughout his career, Mr. Depp has retained advisors in whom he placed his trust to uphold their fiduciary duties and to act properly on his behalf with respect to the management of his personal, legal, and business-related affairs. Mr. Depp relied on these fiduciaries to use the judgment and expertise to act in Mr. Depp's best interest and always put his interests ahead of their own. In or around 1999, well after Mr. Depp had become a critically acclaimed and enormously successful actor, Mr. Depp was introduced to the defendants Bloom and Hergott. After speaking with Mr. Depp's defendants began acting as his lawyers. Defendants engage in conflict of interest, self-dealing, and failures to disclose material information to Mr. Depp. Mr. Depp trusted and relied upon defendants as his lawyers to review contracts and other legal documents to terrible with the deadline, to ensure that they protected Mr. Depp's interest, to prepare and review corporate documents, and to advise him regarding other legal issues that arose with respect to his professional activities. I just want to say, I just mentioned deadline because this was an attachment in the unsealed documents. Elaine, Amber Heard, they attached this to their motion in limines against this. They didn't even bother to go buy an actual copy from the LA courts. They used a deadline copyrighted watermarked copy of this complaint. They didn't even go get their own. That's how lazy they are. Mr. Depp trusted and relied upon defendants as his lawyers to review contracts and other legal documents to ensure. I read that, sorry. However, defendants failed to protect Mr. Depp's interest or to competently advise him. Defendants engaged in self-dealing and failed to disclose material information to Mr. Depp, including their conflicts of interest. Defendants placed their interest above those of Mr. Depp's in the breach of their fiduciary duties and obligations under California law. A clear example of defendants' conflicts of interest, self-dealing, and breaches of fiduciary duty is their sourcing of an improper and predatory hard money loan purportedly on behalf of Mr. Depp through a special financial company, Grosvenor Park Media. The hard money loan, in addition to its egregious self-dealing features, involved terms that were materially worse than they were generally available to Mr. Depp through a standard commercial loan, including with regard to interest and fees charged and other material items. In or around May or June of 2014, TMG's mismanagement of Mr. Depp's financial affairs created the prospect that TMG would be unable to meet Mr. Depp's then current obligations for him. TMG consulted closely with defendants regarding Mr. Depp's financial affairs, but TMG and defendants, that's the lawyers, Bloom, did not disclose to Mr. Depp the true state of his financial affairs and their own wrongdoing. Instead, TMG and the lawyers, Bloom and Hergott, secured for themselves a stream of lucrative contingent fee payments taken without the statutorily prescribed client protective provisions of Section 6147 funded out of Mr. Depp's earnings. Upon information and belief, TMG sought and received defendants' assistance in effecting this effort. Upon information and belief, defendants, the lawyers, never questioned TMG's financial management of Mr. Depp's affairs or investigated TMG's explanation for the deterioration of Mr. Depp's financial position as a reasonably competent lawyer would. Nor did defendants adequately and truthfully inform Mr. Depp of defendants' own conduct and activities. On information and belief in furtherance of the scheme, defendants, the lawyers, introduced TMG to Grosvenor Park in order to obtain a hard money loan, purportedly on Mr. Depp's behalf, but in reality, to his detriment, and to defendants TMG's and Grosvenor Park's benefit. On the information and belief, defendants have had professional relationships which they failed to communicate to Mr. Depp in breach of the rules of professional responsibility with Grosvenor Park and or its founder, CEO, Donald Starr. In fact, Mr. Bloom ultimately was given a position on the advisory board of Grosvenor Park. Defendants never disclosed to Mr. Depp the material conflicts of interest raised by these relationships. Ooh, disclose. That's a big one. So Bloom was actually a part of this company. He was on the advisory board of this company that ultimately gave Johnny this loan at bad rates. Together, the TMG and Grosvenor Park defendants orchestrated an initial $12.5 million hard money loan purportedly on Mr. Depp's behalf from a lender and information and belief of an affiliate of Grosvenor Park, Tryon Management Services. This loan was later increased to $19 million, and this was a really bad loan. On information and belief, defendants were actively involved in negotiating the Tryon loan on behalf of Mr. Depp. On information and belief, defendants negotiated directly with film studios to secure Mr. Depp's residuals from the films as collateral for the loan. Defendants also were updated frequently on the status of the loan paperwork by TMG, were consulted regarding the loan's terms, and were included in communications regarding the loan. So TMG was directly involved with Jacob Bloom in knowing all the terms of this loan. Defendants and TMG structured the loan without the legally required disclosures to Mr. Depp as a vehicle to provide themselves with immediate priority to millions of dollars of voidable contingency fees tied to the success of Mr. Depp's film residuals. The fees the defendants were not legally owed, all before Mr. Depp received a cent. So they tied up a bunch of his residuals from movies to go automatically pay this loan back, not turn it into a problem, as I understand it. The terms of the Tryon loan required that repayment would be made from and secured by Mr. Depp's residuals from 6 films, Pirates, Alice, Into the Woods, collectively. It also appears that defendants with TMG inserted different numbers for different film residuals, including a 22.22% fee for advisors for one movie. Their changing of the numbers in this contract illustrates defendant Bloom, along with TMG's unfettered control to establish a contractual entitlement that was in his and TMG's best interest at the expense of his clients. Remarkably, the loan negotiated ostensibly, I hate the deadlines there, to benefit Mr. Depp, wrongly purported to manufacture and insert further rights for defendants and TMG in the residuals of Mr. Depp's movies that they did not legally possess, using the vehicle of the hard money loan sourced through an undisclosed relationship of defendants. Remember, Bloom was on the advisory board. Further, the loan prioritized payment of defendants and TMG's fees ahead of the loan payments owed to Tryon. So they took this money, and TMG and Bloom continued to work for Johnny and made sure to pay themselves out of this loan first, rather than make the loan payments back to Tryon. And regardless of whether Mr. Depp actually retained any of the loan proceeds, the purported contingent fees and preferred payment position provided defendants and TMG with the right to fees superior to Mr. Depp's own, creating additional serious conflicts of interest. This payment structure deepened Mr. Depp's financial difficulties and benefited defendants and TMG. What they did was horrible. Defendants and TMG legally voidable contingent fees, which did not and could not satisfy the client protective statutory prescriptions of Section 6147, and preferred payment position were inserted at the very beginning of the negotiations on the Tryon loan, when TMG and defendants met and negotiated a term sheet with Grosvenor Park and Tryon that included the voidable purported contingent fees. The further underscored defendants and TMG's wrongful focus on assuring the defendants and TMG received an improper stream of payments that they were not legally owed out of Mr. Depp's earnings. 22%, he had said. Defendants benefited immediately from the Tryon loan through their insertion of the improper contingent fee management arrangement in the loan. Upon information and belief on or about the date that the hard money loan proceeds were received, defendants, the lawyers, TMG, and a third party took approximately $1.2 million that was not legally owed to them. Defendants were paid approximately $300,000 at that time. To date, defendants have been paid millions in voidable and improper contingent fees through the Tryon loan. In addition to the improper contingent fee arrangement, the terms of the Tryon loan and fundamental economics of their transaction demonstrate the loan was unnecessary and predatory. Despite the fact that the initial loan was $12.5 million, the film rights pledged to secure the loan yielded Mr. Depp approximately $13 million per year, more annually than the initial loan amount. In fact, during just the first 12 months after the Tryon loan was originated, Mr. Depp would have received $15.2 million in film residuals. Had those residuals not been used to secure the hard money loan, instead, millions of dollars more than the entire initial loan balance were swallowed by the terms of the loan itself. Now wrap yourself around that. They got a $12.5 million loan. In the first year of his residuals were $15.2 million. And yet the loan wasn't getting paid off. Whoops, sorry. Get that back. Further, only 8 days after the loan agreements were signed, the studio paying Mr. Depp's residuals rights paid $5.58 million that would have gone to Mr. Depp, but for the Tryon loan. Thus, the Tryon hard money loan sourced by defendants and originated by Grosvenor Park was not economically rational, at least not for Mr. Depp. Did I miss anything? On the terms, yeah. Defendants in their capacity as Mr. Depp's attorney who had negotiated film deals and the party whom the studio provided notice of such payments knew that Mr. Depp soon would have received these significant residual ownings on the 6 films. All they needed was a short-term bridge loan. They knew this money was coming in. Their predatory hard money loan was further subject to high fees, double-digit interest rates, and repayment terms that provided that accrued interest would be capitalized monthly and added to the principal. It was contained substantially repayment penalties, making it financially infeasible to repay the loan prior to its termination date. For example, if shortly after entering into the Tryon loan, Mr. Depp sought to pay it in full, it would have cost Mr. Depp approximately $1.5 million in origination fees and prepayment fees to pay off the loan, in addition to the entire principal. Although accrued interest was capitalized monthly under the loan documents, Mr. Depp's business entities received film residuals less frequently than monthly, resulting in significant additions to the outstanding principal in between each repayment. In fact, through June 30th, 2017, over $2 million of capitalized interest had been added to the principal balance of the loan, on which further interest is charged. This is my understanding of what happened. You have a loan, you have a monthly payment. Johnny's residuals were not paid monthly. Maybe they were paid quarterly. Let's say they were every 3 months. That means this loan, because it was only taking payments for the residuals, would have a month of no payment, penalties and interest, a second month of no payment and penalties, and the third month would take the residuals. The loan was basically set up for him to fail. Defendants and TMG knew or should have known that the terms of this hard money loan would place Mr. Depp in a dramatically worse financial position than he had previously occupied, but they willfully, recklessly, and negligently orchestrated it, and they caused him to enter into the conflicted and self-dealing transactions, merely providing him signature pages, not the underlying loan documents, and without explaining its terms. I think even with the documents, I don't think I would have understood what was going on. All he needed was a short-term bridge loan. As a direct result of and remember, they're getting fees too. They're getting about 22% out of the loan. As a direct result of their actions, defendants and TMG caused Mr. Depp to forgo terms tens of millions of dollars or on annual earnings from residuals from the films that had provided Mr. Depp with regular and substantial income to date, and that, for that predatory hard money loan, would have continued to do so. If they'd just gotten the bridge loan, they could have paid that up, and he would have had all those residuals coming to him. Instead, they got tied up with this loan. It wasn't being paid on time monthly, so the loan kept getting bigger and bigger with added fees and added interest. Nevertheless, when it came time to enter into the self-serving transaction, defendants did not disclose to Mr. Depp the conflicts of interest caused by defendants' professional relationships with Grosvenor Park, in violation of their ethical obligation to disclose conflicts to and obtain informed written consent from their client. Nor did they adequately disclose to Mr. Depp that the Tryon loan was hard money loan with unnecessarily onerous, one-sided, and non-standard financial terms, that repayments would be made from and collateralized by the films, and the defendants and TMG used the hard money loan as a vehicle to attempt to obtain contingency fees for themselves, which, as explained below, were voidable and to which they had no legal right in the first place. When he's saying they're voidable, these contingency fees or these percents, I do business for you, you pay me 10%, it was a verbal agreement. It wasn't a written contract. Therefore, Johnny's claiming that contract was voidable because it was only verbal. Therefore, these contingency fees were voidable. That would further be prioritized and paid before any amount would be applied to reduce the amount owed by Mr. Depp. So they're taking everything off. They're making sure their bills are paid right from the top. By providing themselves with these benefits at their client's expense without the legally required disclosures and required client-informed consent, defendants breached their duty of care, breached their duty of reasonable communication, engaged in egregious self-dealing, and breached their duty of loyalty. In the end, Mr. Depp was presented with only the signature pages of the loan documents and, trusting that his advisors had his best interests in mind, signed the loan documents, not appreciating the devastating impact the hard money loan, the product of brazen self-dealing and conflict of interest, would have on his financial condition. And this all became known because Ed White came in and they did the deep audit. And they also tried to refinance and reposition a lot of loans, and they found they couldn't with this loan. Over the approximately 3-year period since the Tryon loan was initiated, Mr. Depp should have received a total of $32 million in residuals from the films. Instead, Mr. Depp received nothing. $9 million of his film residuals were directed to the payment of Mr. Depp's tax liabilities on his contingent earnings, with the balance being paid to the defendants, TMG, Mr. Depp's agent, and a third party to the lender, with whom defendants also had and have an undisclosed relationship with. Moreover, Tryon asserts that Mr. Depp still owes approximately $5 million on the hard money loan. So let's look at those numbers again. He made $32 million income, $9 million obviously go pay for his taxes, and he still has a $5 million balance, which continue. And this is as of now. The loan was taken out a while ago. On a hard money loan, which continues to capitalize substantial interest at unreasonable rates, and Tryon continues to charge unreasonable fees in servicing the loan. In sum, had defendants provided full disclosure about the terms and facts surrounding the hard money loan, as required by multiple California statutes and the rules of professional responsibility, neither Mr. Depp nor any reasonable, sorry, my phone got buried up here, or any reasonable person would have agreed to enter into it. No reasonable and prudent attorney under the circumstances would have recommended the Tryon loan to their client, nor affected it in the manner the defendants did. It did not make economic sense and seemingly was for the benefit primarily of defendants and TMG, who took millions in fees from it. Even if a loan was required, defendants and TMG could and should have obtained a loan on the normal commercial terms Mr. Depp's new business managers obtained shortly after Mr. Depp disengaged with TMG. TMG tried to claim like, we couldn't, this is the best we could get. We couldn't get better terms. And Ed White's like, I just refinanced a whole bunch. I just did this. The transaction has cost Mr. Depp millions of dollars in unreasonable interest fees and voidable contingent fees that were self-servingly inserted as a provision in the hard money Tryon loan without the statutorily prescribed contract, written disclosures, or informed consent that defendants were required to make and obtain under the circumstances. Had defendants acted in accord with their fiduciary duties, made the required disclosures, and fulfilled their professional responsibilities, neither Mr. Depp nor any reasonable person would ever have entered into the Trian loan transactions. The loan was commercially unreasonable, rife with self-dealing, and contained onerous, unfair, and voidable terms that have cost Mr. Depp many millions of dollars. The voidable terms was because they didn't have right to their contingency fees. As another disturbing illustration of defendants' breach of their duties to Mr. Depp, Defendant Bloom received advance notice from TMG's Joel Mandel many months after Mr. Depp had terminated Mr. Mandel that Mandel on Mr. Depp's home. So his lawyer knew months before that Mandel was going to file this, because Mandel got whiffed that Johnny was going to fire him. He was moving on to another business manager. After the foreclosure action commenced in January 2017, Defendant Bloom admitted to Mr. Depp that he had advanced knowledge of the foreclosure action. Tellingly, Defendant Bloom offered no explanation why he withheld this important information from his client. Now, we've just seen what's happened in this loan. When I'm done here, I'll explain what happened with the foreclosure, because that was horrendous also, what they pulled on him. Furthermore, throughout the course of the defendant's relationship with Mr. Depp on multiple occasions, and notwithstanding the lack of the statutory prescribed written fee agreement, that's what's going to come in, defendants would submit to TMG request reimbursement of alleged expenses. A former TMG employee who was the day-to-day manager of Mr. Depp's account at TMG testified that defendants submitted requests for expense reimbursement with little to no supporting documentation, which TMG would then pay without question for Mr. Depp's funds. The former TMG employee's sworn testimony is that when she confronted TMG's Mandel to request backup for the defendant's significant expense reimbursement invoices, she was ordered to just pay it. In other words, just pay me. Defendant's expenses and requests for reimbursement were never sent to Mr. Depp for review and approval. And this also goes for defendant being the lawyers. On information and belief, defendants regularly failed to provide any documentation substantiating the claimed expenses, nor were they ever disclosed to Mr. Depp. Over time, on information and belief, defendants submitted hundreds of thousands of dollars of such unsubstantiated expenses for reimbursement, which TMG ultimately paid to defendants out of Mr. Depp's funds. That's the lawyers, paying the lawyers. Also on information and belief, unbeknownst to Mr. Depp, TMG and Joel Mandel unilaterally funneled millions of dollars of Mr. Depp's money from Mr. Depp's Switzer trust account into investments in which the Mandels secretly were involved as members and directors, including Lionheart, owned by a mysterious entity called Binary Capital Management, both operating out of Wilmette, Illinois. And the equally mysterious Matter 1 and Matter 2 and 6909 Ventures, LLC. On information and belief, Mr. Mandel wrote the checks in his own hand and using his own signature to move Mr. Depp's money from Switzer Trust account to Mr. Mandel's 6909 Ventures, LLC, which Mr. Mandel manages. Despite defendant Bloom's intimate involvement in Mr. Depp's financial affairs, as reflected among other ways by his sources of the hard money loan, none of the defendant Bloom, TMG, or Joe Mandel discussed these legally impermissible self-dealing transactions and this control and ownership of the investments to Mr. Depp, as they were required by law and the rules of professional responsibility. Now, I think this is all coming as new to you, because even though this is stamped with deadline, they did little to no coverage on Johnny's side of this suit. They were in deep with TMG's reporting of the smear campaign. By the way, and that smear campaign reporting was run by Shane, who was Amber Heard's new PR guy. Defendants violated the California Business Code. California Business and Business Code, designed to protect clients, provides that contingency fee may not be taken by lawyers unless there is a written contingency fee agreement that includes a statement of the contingency fee rate that the client and attorneys have agreed upon, a statement as to how disbursements and costs incurred in the connection with the prosecution of settlement of a claim will affect the contingency fee and the client's recovery, statement as to what extent, if any, the client could be required to pay any compensation to the attorney for related matters that arise out of their relationship not covered by their contingency fee contract, and a statement that the fee is not set by law but is negotiable between the attorney and client. Similarly, California Business and Professional Code provides that except as provided, and in cases where it is reasonably foreseeable that the total expense to a client will exceed $1,000, a lawyer's contract for services must be in writing and include any basis of compensation, including but not limited to hourly rates, statutory fees, flat fees, and a standard rate fees and charge applicable to this case, the general nature of the legal services to be provided the client and the prospective responsibilities of the attorney and the client, the performance of the contract. Well, 22% or whatever they were taking, 10%, far exceeded the $1,000 limit. So their contract should have been in writing. For the protection of clients, any contingency fee agreement that does not comply with the California Business and Professionals Code is voidable at the option of the client. Any other fee arrangement exceeding $1,000 that does not comply is also voidable at the option of the claimant. Notwithstanding these requirements, defendants did not enter into any written statutory prescribed contingency fee agreement with Mr. Depp or any of the plaintiffs for the provision of legal services. Nevertheless, over the years, defendants collected voidable contingent fees totaling in the tens of millions of dollars tied to Mr. Depp's variable earnings. As described in greater detail above, the Tryon loan defendants sourced for Mr. Depp, it appears that defendant with TMG used the hard money loan vehicle as an opportunity to insert voidable contingency fees for themselves, including different fees for different film residuals, such as 22.22% fee for advisors for one movie, all without disclosing these fees or explaining their import to Depp in the legally prescribed written contract. Their changing of the numbers in this contract illustrates defendants, along with TMG, unfettered control over Mr. Depp's affair to establish and obtain for themselves a pecuniary benefit to the expense of Mr. Depp, their client. Defendants' wrongful conduct in this regard underscores the reasons for an importance of a written contract setting forth defendants' fees for their legal services and disclosing the terms and conditions of their engagement as Mr. Depp's lawyers, as California law requires. Defendants violated California Business Professionals Code by taking contingency fees without a written contract containing the statutorily prescribed language. Alternatively, they violated the code by failing to enter into a written contract for services that would plainly exceed $1,000, obviously. In total, defendants improperly obtained approximately $30 million in voidable contingency fees based on Mr. Depp's gross income. Defendants also took hundreds of thousands in additional payments for reimbursement of alleged expenses that were submitted by defendants to TMG without any backup. Throughout their representation, neither defendants nor TMG suggested that the fees taken from Mr. Depp were voidable in the absence of a statutorily prescribed written contract, nor that they impose on themselves or each other a cap or a ceiling on the fees taken. Instead, defendants and TMG, working in tandem, deployed a fox guarding of the henhouse approach, never disclosing to Mr. Depp either California's protective legal requirements for written contingency contracts or the outsized and unconscionable fees TMG paid to itself and defendants from Mr. Depp's funds in the violation of California law. Defendants actively conceal and fail to disclose other wrongdoings. Throughout the course of their representation of Mr. Depp, defendants occupied positions of trust as Mr. Depp's lawyers and were in possession of the records related to their representation. Defendants failed to disclose the misconduct and the misconduct others, which they are well aware. Mr. Depp did not discover and could not have reasonably discovered defendants' wrongful conduct any earlier because defendants actively and willfully concealed Mr. Depp's true legal and financial situation from him. It was less than a year ago when Mr. Depp first had any reason to suspect that the defendants engaged in wrongdoing alleged herein. That's important. It was less than a year ago. So TMG has known for a while that Johnny's been upset and been trying to get information, and that goes to the issue of the foreclosure, which they knew months ago. I'm going to scroll because I think this restates a lot of what they said at top. And I don't want anybody to mess up their eyes. In fact, I'm pretty sure it does. It's now going to assign each of these things to the claims, but it's pretty much just read out for us. So let me pull up one more thing. Well, I forgot he won separately on the oral contracts. So let me pull that up. But in the meantime, let me explain to you my understanding what happened with this foreclosure. TMG issued a loan to Johnny themselves for $10 million. They issued him a loan, and every month they were responsible for paying all of Johnny's payments and expenses. So they were paying Johnny's bills, but they didn't pay back their loan because they were responsible. So it wasn't Johnny Depp who was writing checks every month. It was TMG to pay the bills, to pay the loans, to pay the taxes, to pay whatever. TMG did not pay their own loan back. They held it like a dangling carrot. And when they found out that Johnny was unhappy by not paying their own loan, the loan became in arrears. So they controlled the payment. So when push comes to shove, they said, you know what? We're going to foreclose on your house for non-payment on the loan, for lateness on the loan. Johnny's like, but you're responsible for paying my bills. Why didn't you pay the loan? Not cool, huh? So let's talk about this. This was the Johnny Depp wins an oral contract battle with ex-lawyer. Hollywood is jolted. This was a huge win for Johnny, and affects a lot of how lawyers have to do business now. Lawyers for Johnny Depp and his former attorneys may be talking about a settlement in their $30 million malpractice suit, but today in court, the two sides locked horns, and Hollywood got a potential legal mauling. I appreciate that there are good people in show business, Los Angeles Superior Court Judge Terry Green said this morning as he granted a motion for Depp to declare invalid the oral deal the Pirates of the Caribbean star had with Jacob Bloom and his firm for almost 20 years. Perhaps more important, Green looks to have thrown a spanner of sorts into the Tinseltown works, where many a client and legal rep have made such contingency agreements that have never been put in writing. I know this is already put to the test. I can't think of the celebrities off the top of my head that have cited this ruling. So this is the declaratory ruling. This is the judge saying this. Once this was done, the rest of the lawsuit, as far as the fiduciary responsibilities, et cetera, was to go to a jury. We know they ultimately settled. A lot of people are going to be on the phone today setting a sit down and assigning, one prominent Hollywood attorney told Deadline today of the implications of this ruling. I don't think there are special rules for show business, the judge said. Judge said Tuesday before lawyers for both sides debated whether or not the agreement was a contingency fee deal. I'm aware that show business people sometimes think they live in a special universe, but they don't. I don't see an exception here. The sometimes crusty and sometimes reminiscing Judge Green noted, calling the arrangement between Depp and Bloom clearly a contingency fee agreement. At some point, we have to apply the law, the judge declared, telling the lawyers that if they wanted things to be different, they needed to talk to the legislators in Sacramento about changing the state law, requiring such contracts to be written down. Needless to say, while still permitting elements of their cross-complaint filed in December 2017 to move forward, it was not what Bloom, Hergott, Deemer, Rosenthal, Violet, Feldman, Schenkman, and Goodman LLP or the Reed Smith representatives wanted to hear. Having had their say in court to varying degrees, both lead Reed Smith lawyer Ray Cordazzo and his team and Depp's attorneys, including Patrick Levin and with his Buckley Sander colleagues, exited the courtroom quickly and without comment. Just before moving to the other cases, Green said he would issue a formal ruling on the matter at some point. Washington, D.C.-based lawyer Adam Waldman curtly told Deadline he thought the judge's ruling speaks for itself. So we're still going forward with the trial for the rest of it, but we knew they settled. So let's go back, giving you more history if you don't mind. So soon after this happened, January 24, 2018, it looks like Jacob Bloom's feeling a little heat. Showbiz attorney Jake Bloom's Idaho mansion is up for auction. Here's a few pictures of it. And this is what's important. The uber contemporary art-filled Haley, Idaho mansion of powerhouse entertainment attorney Jake Bloom is headed to the auction at the end of January with a reserve price of $11 million. The scraggly bearded lawyer, whose Hollywood A-list clients include Jerry Bruckheimer and Jackie Chan, initially and unsuccessfully attempted to sell the resort-like Rocky Mountain retreat last year with a too optimistic price of $18 million. Now, this is dated January 2018. Last year is December 2017. I don't have the original listing, but I think Johnny's lawsuit that was filed back in October, I think Bloom knew the writing was on the wall. At one time, Bloom also repped the financially embattled Johnny Depp, who last year filed a $30 million See, last year, 30 million malpractice lawsuit against Bloom, whose firm filed a countersuit. So this is the home. There's Jake. We know they settled. Let's see what happened. Oh, I'm going to have to close this. Jake Bloom and Alan Hergott to retire as Johnny Depp trial nears. So they haven't even settled yet. They lost on the attorney fees, right? It had to be written. They're going to court over the rest. And all of a sudden, the two lawyers that Johnny used are set to retire. And of course, Jake can't sell his house either. So this is May of 2019. I think I'm going to have to close that video out before it starts on me. There. Going back. Bear with me. Okay. All right, that's good. Attorneys Jake Bloom and Alan Hergott have announced that they are retiring from their namesake law firm, while still embroiled in litigation with former client Johnny Depp. Bloom has represented stars like Nicolas Cage, Arnold Schwarzenegger, and Jason Statham, among many others in long career in Hollywood. Hergott represented Brad Pitt, past test, Brad Pitt, Kathleen Kennedy, Russell Crowe. Their firm, with the unwieldy name of Bloom, Hergott, Demore, Rosenthal, LaViolette, Feldman, Shankman, and Goodman, has been renamed to Goodman, Shankman, and Breacham. Many of the firm's former clients will stay. So they're staying with these lawyers, but obviously the other ones are retiring. We thank Jake and Alan for their many years of leadership, excellence, and friendship, and we're happy to build their foundation, partner Carlos Goodman said in a statement. This generational shift positions us to capture growth opportunities and lead GSB's patients into practice into the future. I think they were booted out. They were told, look what you've done to us. Get out. Bloom did not issue a comment, but Hergott said it was time for an evolution. So he's admitting. He's not admitting that it's time for me to retire. He's admitting that there has to be a change to the firm. It has been a rare privilege to represent some of the most talented people in entertainment media for so many years. While I will miss my clients and colleagues now, and now is the right time for this evolution. It's an exciting opportunity for everyone involved, and I look forward to watching GSB optimize the new media landscape for its clients and continue to grow in the future. The pair typically did their work without a lot of fanfare or press attention, but in the last year and a half, there's been a very public dispute with Depp. Depp has accused the firm of mishandling various matters, including his divorce from actress Amber Heard, and alleges that the firm improperly took millions of dollars in fees. So, yeah, this is 2019. Depp was involved in a similar dispute with the management group, his former company, but while that case ended in settlement, the battle for Bloom's firm has dragged on. I think this is a more egregious lawsuit in my reading. In August 2018, an LA Superior Court judge handed him a significant victory, refusing to dismiss the case and chastising the firm for relying on an unwritten agreement with the star. Basically, Johnny could say, you know what, you owe me all those contingency fees. And in the countersuit, what Hergott and Bloom are saying, well, wait a minute, we did work for you, so you still have to pay us something reasonable. Today, Bloom, Hergott fulfilled their lawyer's previous threat to evade. Oh, this is from Adam. Today, Bloom, Hergott fulfilled their lawyer's previous threat to evade their liability to Johnny Depp by shutting down the firm and reconstituting it. We will see whatever firm they want to bring to the court soon. So this has been going on behind the scenes. They were like, you know what? We're just going to close the firm down and then you can't sue us. This case is currently set to go to trial in September. The statement just said that these are the attorneys who are going to stay on. Well, that was interesting. So they get sued, and it reads to me pretty serious. I mean, I think this was a far more serious lawsuit than the TMG one. Jacob can't sell his house. He puts it up for auction almost months later. The judge ruled in favor of Johnny for the oral contracts. And now the law firm is like, you know what, we're just going to shut down, boot these two out, and we're not going to be part of this lawsuit. And then Adam is like, yeah, well, we'll see which lawyers are coming to the table then, because they still worked for you at the time. And I think that pretty much covers that part of it. So now let's get to what went on with the unsealed documents. That's what this video came about for. So this is the plaintiff's file in the limines. Benefits, defendant's motion in limine number 13. Okay, so I'm sorry. Let me go back. Amber Heard filed a motion in limine that they wanted to include the testimony of Jacob Bloom. Depp has filed against that. And his reasons, I mean, I can't believe that they're fighting for it. All right. Plaintiff and counterclaim defendant Depp by counsel and for the reasons set forth fully below moves this court to exclude the deposition testimony of Jacob Bloom. So I think I read that wrong. So this is Johnny Depp's motions in limine. So this is his argument. He wants Bloom's testimony to not go forward. Ms. Heard's counsel has conducted discovery in an abusive manner and should be precluded from introducing certain utterly irrelevant and harassing evidence at discovery. Ms. Heard's counsel deposed Mr. Depp's former attorney of 17 years, Jacob Bloom, who is elderly and appeared to not be able to remember anything of significance. Bafflingly, even though Mr. Bloom's testimony was essentially a string of responses to the effect of, I don't know, Ms. Heard's counsel has designated his deposition testimony for trial. But Bloom's responses establish, 1, that he has nothing relevant to say, 2, that he lacks competence to provide testimony at the issues involved, and 3, the blatantly harassing conduct of Ms. Heard in this action. The deposition testimony should be excluded. At the outset, the transcript makes clear that Mr. Bloom's lacked the ability at his deposition to testify in a competent manner, to recollect or communicate events, or provide substantive answers to questions asked of him. The parties were well aware that Mr. Bloom had been diagnosed with dementia. Nevertheless, Ms. Heard insisted on taking Mr. Bloom's deposition to discuss events that were beyond Mr. Bloom's capacity to recall. It is clear from Mr. Bloom's testimony that he was unable to recall many of the questions posed to him. In fact, throughout the deposition, Mr. Bloom had the assistance of his attorney to guide him in the understanding the questions and provide an intelligible response. Throughout the deposition, Ms. Heard's counsel harassed Mr. Bloom with the same questions repeatedly in attempts to deceive Mr. Bloom. Question: when did you first meet Mr. Depp? Bloom: I don't know. I don't know when. I can't remember. Question: they show him something. Does that help refresh your recollection of when you began representation of Mr. Depp? Bloom: no, it doesn't. It doesn't recall. I don't recall. And I say it strongly to you. I don't recall the particular causes of actions, etc. So he doesn't even remember the cause of action of the lawsuits. Question: do you recall beginning representing Mr. Depp in 1999? Bloom: I don't recall. Mr. Chu: several times? Question: I'm sorry, what is your answer, Mr. Bloom? Bloom: I don't know. It's all confusing to me. Moreover, the substance of Mr. Bloom's deposition sought testimony regarding Mr. Depp's previous litigations, which are completely immaterial to this action. Even if that were not the case, Mr. Bloom did not recall much of the work he did for Mr. Depp many years ago. Ms. Heard should be precluded from exploiting Mr. Bloom further at trial where he does not have any knowledge of her allegations against Mr. Depp, which is the only pertinent issue in this case. For foregoing reasons, plaintiff respectfully requests that the court grant the motion. So as far as we know, the past litigations didn't come in, other than casually, did you know about his lawsuit with Brooks? I think that did just get mentioned. And I do know that Joe Mandel did testify. So let's look at a little bit of this transcript at his deposition. Sorry, I'm scrolling, guys. What's your specialty? Mr. Singer. This is Marty Singer. Now, we'll find out that he was the one who worked with Bloom. And that's how Johnny got to know him. And he's the one who helped Amber Heard with the doggy gate in Australia. What was your specialty while you were practicing law? Bloom. I was an entertainment lawyer. Question: and was that in Los Angeles, California? Bloom. Yes. Question: can you please describe examples of clients that you've had over the years in the entertainment industry? And we're going to label this confidential, so it'll be under seal. Marty Singer, Bloom's lawyer: I'm going to object. It's immaterial who Mr. Bloom's clients are. He represented Mr. Depp. He represented many other people in the industry. Let's just get into the issues that relate to this case. Question: when did you first meet Mr. Depp? Answer: I don't know. I can't remember. Question: you performed services for Mr. Depp over a period of time. Is that correct? Yeah. Mr. Chu: says, and Mr. Bloom, obviously that's fine to answer in a generic way. I'm going to be instructing you on behalf of your cross complaint against Mr. Depp. No, I don't remember. We jumped pages 9 to 55. Yeah. Jump pages. I don't, do you remember? So Bloom had filed a cross complaint against Mr. Depp. I don't know. I don't remember. Okay. I'm going to ask you to turn to paragraph 10, and it says there, beginning in 1999, Bloom Hergott or its predecessors provided entertainment-related legal expenses to the cross defendant, Johnny Depp. Does that help refresh your recollection of when you began representation for Mr. Depp? Bloom. No, it doesn't. It doesn't recall. I don't recall. And I say it strongly to you. I don't recall the particular cause of action, etc. Do you recall beginning representation in 1999? Chu. Objection. Asked and answered. Bloom. I don't recall. Mr. Chu. Several times he said this. He said this. Question. I'm sorry. What's your answer, Mr. Bloom? Answer. I don't know. It's all confusing to me. Jumping pages. Do you have any knowledge of any domestic violence by Mr. Depp against Miss Heard? Chu. Objection. Witness. No. Chu. Argumentative. Leading. Assumes facts contrary to the record. Witness. No. Do you have any knowledge of any allegations by Mr. Depp of domestic abuse by Miss Heard? No. Now it says further along, kindly let me know at your earliest convenience if you and your client are agreeable to do so, as well as which judicial officers are acceptable. Upon hearing from you, I will have my assistants obtain rates and availabilities, and it's the context of proposing private retired judicial officers. Do you have any recollection of responding to this and indicating whether you had any objection to these judicial officers? I think this is from the demand letter that Amber Heard sent as part of her divorce, where they wanted the condos and stuff, and they wanted to arbitrate. They wanted to quiet. They wanted to get a retired judge. I think that's what they're referring to here. So he's not remembering any of this. And rightfully so, Ben Chu on Johnny Depp's behalf is like, look, first of all, this has nothing to do, I'm sorry, I'm scrolling, it's habit. This has nothing to do with the lawsuit. It's a defamation lawsuit. It's a defamation lawsuit. I'm sorry, I thought I got disconnected for a minute. This is not related to him suing over his lawyers over mismanaging his funds. It's got nothing to do with it. But as much as this went down, Elaine Bredehoft is fighting. She wants, absolutely 100% wants Bloom's testimony in. And after knowing he's got dementia. And this is what she argues. Mr. Depp has presented no evidence that Mr. Bloom lacks competence. Mr. Depp makes the outlandish contention that Mr. Bloom's testimony shows he lacks competence to serve as a witness. Rule 2601 provides that every person is competent to be a witness except as otherwise provided by other evidentiary principles, rules of court. The language of this rule embodies a presumption that every prospective witness is considered competent. The competency of the witness depends on his capacity to accurately to observe, remember, and communicate facts. And it is the role of the trial court to, in the exercise of his discretion, to determine the competency of the witnesses. The role of the trial court, Judge Escarati. Mr. Depp has not identified any basis for setting aside the presumption of competence. He asserts without any support whatsoever that Mr. Bloom has been diagnosed with dementia. Well, Mr. Bloom was represented by attorney there. Absent evidence of this assertion, however, the court cannot consider this alleged diagnosis. Mr. Depp further claims that at Mr. Depp's deposition, he was unable to communicate about relevant events, provide substantive answers, and recall questions posed to him. But Mr. Depp fails to cite a single instance of this occurring that is reflected in the deposition transcript. I think we just saw he doesn't remember anything. While Mr. Bloom's testimony, remember, she's opposing this, so she's already read Ben's motion here. While Mr. Bloom's testimony showed that he has difficulty remembering certain events, that is not the grounds for excluding his testimony altogether. Lack of clear recollection may affect the weight of a witness's testimony, but it does not deprive of its probative value. The weight given to the evidence and determination of the witness credibility are matters for the fact finder to decide. That's the jury, the fact finders. Finally, general obligation to the competency of a witness should be overruled if the witness is competent for any purpose. Mr. Depp seeks to exclude all of Mr. Bloom's testimony, and his general objections should be overruled. Alternatively, to the extent the court finds Mr. Bloom is not competent to testify to certain events, he should be permitted to testify to those that he can recall. Ms. Heard's counsel did not harass Mr. Bloom during his deposition. Mr. Depp maintains that Ms. Heard's counsel harassed Mr. Bloom with the same questions repeatedly in attempts to deceive Mr. Bloom. The sole example he cites in support is an attempt by Ms. Heard's counsel to refresh Mr. Bloom's memory with respect to when he began representing Mr. Depp. Such behavior is not harassment and provides no basis for excluding Mr. Bloom's testimony. Except he said he didn't remember any of this. For this reasons, the motion in limine 11 should be denied. So let's take a look at more of this. And some of this may overlap, but I think I want you to see more of the questionings that Elaine was using. So they were talking about the postnuptial agreement. That was important for Johnny, that the argument in Australia was because he wanted a postnuptial agreement. And she was arguing with Bloom. I object and instruct the witness not to answer to the extent that it would require him to disclose communications that he had with Mr. Depp. Because remember, he was still his lawyer at the time. Ms. Bredehoft, I'm not asking that. I'm asking very specifically, have you ever had any conversation with Amber Heard about a prenuptial agreement or a postnuptial agreement? I don't think you can answer that without divulging communications he had with the client. Marty Singer, you can answer it. Question, okay, let's try again. Singer, excuse me, you can answer the question if you recall ever having any conversation with Amber Heard alone, Amber Heard bringing up the subject of a prenup or postnup. Do you ever remember that being discussed with her? No. Well, this goes to Elaine's favor because Johnny claimed that Amber Heard was arguing with the lawyers about the prenup, postnup. But I believe that, and so did Ben Chu, and apparently so did Judge Ascarati, saying, do you ever remember? No, I don't remember anything. Not that I don't remember discussing it with her because it didn't happen. I don't remember anything. And Elaine knew that these are the types of answers she was now going to get, and that's how she was molding her questions, in my opinion. She was trying to elicit no. Have you ever had any communications with Amber Heard about issues in Australia about the dogs? With what? With dogs, them bringing the dogs into Australia. No, which I find interesting because she did have communications with Marty Singer, who's sitting there. You've not had any conversations or communication with Amber Heard about that. Is that correct? No, strongly, no. Okay, and I asked you that, and I asked that so badly. My apologies. So when you say no, no is strongly no. You have not had any communications with Amber. Is that correct about the dogs in Australia? Yes. Okay, thank you. Have you ever seen Amber Heard together in person? Have you ever seen Amber Heard together in person? I don't know what he means. I think he just means, have you ever seen Amber Heard? Yes, I did meet her at various birthdays where she was celebrating her birthday. Do you recall how many times that was? 6 or 7. Well, we know he wasn't there April 22nd of 2016. So he's saying 6 or 7 birthdays of Amber Heard. That's 6 or 7 years. Were you at birthday celebrations where Amber Heard was celebrating her birthday? Yes. And you think that was 6 occasions approximately? Yeah. What do you recall from any of those birthday celebrations? Nothing specific. Do you recall anything more generally about them? Any impressions you had? No. You just recall that there was a birthday celebration. Yes. Do you recall observing any kind of interactions between Miss Heard and Mr. Depp at any of these birthday celebrations? Inaudible. Chu, objection, vague and ambiguous. Mr. Singer, he answered no. Bredehoft, did you get that, Amy? Reporter, okay. Mr. Bloom, I'm sorry. I need you to repeat your answer. No, thank you. Can we pull up Exhibit 8, please? It's marked. Doesn't mean anything to us. Mr. Bloom, I'm going to try and blow this up. First of all, so it goes a little bit bigger. So basically, she was eliciting questions knowing she was going to get it. No, I don't remember. And to say it was 6 or 7 birthdays at 6 or 7 years. So that obviously is not correct. What do we know from this? Well, we know that Bloom did not testify and that Judge Ascarati agreed that he wasn't able to. But I just think it was very clear he was confused, didn't remember anything, and Elaine was coercing the questioning, knowing she was going to get, I don't recall, I don't know, or a no answer that she could use or hope to use for Amber's benefit. So that's what happened with the Bloom liminees. And I'm going to limit it to this, and I'll be posting this up as part of my short series on the unsealed documents. So I hope you found this interesting. I'm doing a bit more of a deep dive that the other lawyers who all said they came into this case. Almost made it. They came into this case with a clear head because they wanted to face it like the jury. So they didn't have any of this history. So I hope you enjoyed it. I'll be doing more. Like, subscribe, notify, all the bells and whistles. I appreciate it. And thank you for watching today.